Good afternoon, everyone. Thank you for, can everybody hear me? Can the folks on Zoom just let me know if you all mic on me? It is. Thank you for having me here today, and thank you to Dan for inviting me to come speak with you all about environmental protection and the work of the South Carolina Environmental Law Project. As Dan said, my name is Michael Martinez, and I've been with the South Carolina Environmental Law Project, or SCELP, for a little over a year now. I started in January of 2021. To briefly expand on my personal history, when I went to law school and when I graduated law school, environmental law really was not on my radar. I wanted to practice criminal law at the trial level, and so I accepted a job with the Greenville County Public Defender's Office. And one of the other things that I wanted was to move to Greenville. I went to school at the University of South Carolina School of Law in Columbia, and I wanted to move up this way because I have a passion and a love for the outdoors, and Greenville has just incredible opportunities for outdoor recreation so close by. And so over the time that I've lived here, I've been able to enjoy all the state parks that we have around here, all the great hiking opportunities in Western North Carolina and Pisgah National Forest. And I began to recognize the need for continued preservation and protection of these spaces that I love so much. And I began to wonder if I could use my legal skills and legal knowledge to protect these places that I treasure. And so in the fall of 2020, I began just periodically looking at job postings and came upon one for the South Carolina Environmental Law Project. And their mission really spoke to me. If I can get this to... There we go. Their mission really spoke to me. As you can see, we use our legal expertise to protect land, water, communities across South Carolina. And I felt that that fit right within exactly what I wanted to do. And SCELP, briefly about SCELP, it's a nonprofit organization funded primarily by private donations and grants. And we are also a public interest law firm. And so we're unique from your traditional advocacy organizations like, say, an Upstate Forever that you might be familiar with. We provide general advocacy and policy influence at the state, local, and national levels, but our unique role is to provide legal intervention to enforce our laws and to ensure that the laws that are in existence can be improved and as well as enforced. And so I was fortunate enough to join this dedicated group of lawyers and staff who have a passion for protecting and preserving the environment. I'm actually not in this photo because I was getting married in Glacier National Park last October. And as you can tell from that location, my wife and I both really love the outdoors, and it just really fit in with this work really fit in with my personal beliefs and commitment. We're a pretty tight-knit group. We get to do outings like the one you see here. We're kayaking in the Black River Cypress Preserve down in the Low Country near the Georgetown Andrews area. It's just a great opportunity for us to get out of the abstract and really see and experience these spaces that we work every day so hard to protect. We have 4 focus areas: coastal management, water and wetlands, wildlife and habitat conservation, and landfills, nuclear and toxic waste. In the coastal management section, we seek to improve and protect vital ecosystems by preventing alteration and degradation of those areas while advocating for decisions that account for climate change and sea level rise. So this category includes cases like our Harbor Island Beach Houses case. This is a case in a private community in the Beaufort area where, due to excessive erosion, severe erosion of the beach, the houses are literally stranded in the ocean and have become uninhabitable. They're inundated by seawater, and daily the waves crash against them, causing the construction materials of the house to fall off and onto the beach and into the water. And so we have engaged in legal action to have those houses removed from the beach and from the ocean. Our water and wetlands section, we seek to prevent degradation of our water resources through uses that would either pollute or result in a harmful decrease in the availability of fresh water, dealing with both the related issues of water quality and water quantity. Wildlife and habitat conservation in this area, we seek to protect wildlife and their critical habitats. This is a case, this includes cases like opposing a luxury resort on Bay Point Island down in the Low Country, a coastal barrier island that supports extremely diverse wildlife habitats. We have intervened in an appeal from the zoning board denying this particular development, and to ensure that our clients' rights are represented at that level so that this island remains pristine. Finally, landfills, nuclear and toxic waste. This area addresses, as you can tell, solid waste landfills in our state. It seeks to strengthen the regulatory permitting processes for these types of facilities. This category includes issues like the legacy contamination present at the site of the former Bramlett Road manufactured gas plant, which is here in Greenville. This is a site that back in between the 1920s and the 1950s operated as a manufactured gas plant. It was the predecessor to natural gas. And part of the operations, it would discharge wastewater that had coal tar and coal tar contaminants. And this is located just north of Unity Park. And the groundwater and soil there has legacy contamination on site that we are pushing DHEC to require Duke Energy to restore the wetlands of the Reed River. This is located in the floodplain in the wetlands of the Reed River, and ensure that this site does not pose any public health risks. As you can see, our cases are really throughout the state. While the majority of them are on the coast, we've been operating since 1987. Most recently, in the last few years, expanded into the Upstate with the Greenville office, where I work, and then most recently in Columbia. Just want to briefly touch on a few of our major cases that you may have heard of. Captain Sam Spit has somewhat of a tortured procedural history. This issue has been ongoing for about 15 years. Over the course of the last 15 years, developers have sought to obtain permits to install various types of erosion control structures along this spit. And this is Captain Sam Spit is a 170-acre barrier island on the southern end of Kiowa Island. It is only one of three undeveloped, publicly accessible barrier islands in the state. The other two are state parks, Huntington Beach State Park and Hunting Island State Park. So you can understand the pristine nature of this type of island. So the developers wanted to install this erosion control structure so they can build a road along the island so that they can provide access to 50 luxury residences that they want to build.
On that spit?
Yep. The problem with these structures is ultimately the erosion would result in the elimination of that sandy shoreline, and it would either be a bulkhead and a revetment, a bulkhead alone, or a steel wall. These are all the different iterations that they have sought to install here. And ultimately, the erosion from the Kiowa River would mean that the Kiowa River, the wall, the erosion structure would become part of that shoreline, and it would eliminate the public's access and use of that shoreline. And what was important about this case, and this case has been before the South Carolina Supreme Court 3 or 4 times, and the court has repeatedly rejected these permits because it violates what's called the public trust doctrine. And what the public trust doctrine says is that the land below the mean high water mark is land held in trust for the public. And the Coastal Zone Management Act seeks to implement that trust doctrine so that any development that happens in that area, the critical area, is for the maximum public benefit. And so the court has repeatedly held that this has to be for the maximum public benefit, and this structure would eliminate that use. And this was most recently last fall that the court again rejected this. So we're not sure if the developers will again seek to try a different strategy to be able to build these houses, but that is ongoing, and we will continue to fight it until they no longer want to build there.
What's the ownership of that right now?
It's a development group.
So it's privately owned.
Yes, sir. Yep. Going back, Angelo, which some of you may have visited down in the city of Charleston. It's an incredible tree. It's estimated to be somewhere around 500 years old, though some estimate it to be as much as 1,500 years old. Incredibly, I just recently learned this myself. Its shade covers 17,200 square feet. What happened here was a developer owned about 36 acres on the northern edge of the area surrounding the Angelo, and they wanted to build over 600 residences and 80,000 square feet of retail, including big box retail. We challenged the development permits in the administrative law court, which is the venue where we most often challenge permits, because DHEC as the agency is the one that issues the permits. So we challenged it there and presented expert testimony that this development would negatively affect the roots of the tree, would affect its hydrology, and would ultimately negatively affect its health and lessen the lifespan of the tree. While we lost at the administrative law court level, which is effectively the trial level for administrative law courts, we appealed to the Court of Appeals, and while that was pending, the developer's lender foreclosed on the property, and this allowed us to facilitate a settlement agreement that was extremely beneficial, so that the Low Country Land Trust could purchase the property, and now 42 acres, the 42 acres surrounding the Angelo is permanently preserved and protected.
Fantastic. Yeah. Okay.
This, you probably don't recognize it, but I think you all will be familiar with it. That is the Savannah River site. This is one of our newer cases. Essentially, the U.S. Department of Energy and the National Nuclear Security Administration recently made a decision to produce plutonium pits at the Savannah River site, as well as the Los Alamos National Laboratory in New Mexico. This site has never produced plutonium pits, and as a brief background, plutonium pits is the essential core to a nuclear bomb. And so we filed a lawsuit in federal court challenging this decision And the basis for our lawsuit was that the Department of Energy and the NNSA violated the National Environmental Policy Act, which is also known as NEPA, and it's one of the bedrock statutes for environmental protection in the country. And essentially what NEPA requires is that when federal agencies are going to take some sort of major federal action, they have to evaluate all the impacts of that action on the quality of the human environment. And there's a long history related to the site, related to the production of these pits. And essentially, our argument is that they failed to do an adequate program-wide, system-wide environmental impact statement that evaluated all the impacts of this proposed decision to make, in total, 80 plutonium pits a year. And some of the things that we allege is that they failed to evaluate the impacts on all the Department of Energy sites that would be involved in the production of this, the storage capacity for the nuclear waste that would be generated as part of the production of these pits, and the changes in the plan since prior analyses also require a new program-wide evaluation that assesses ways to avoid or mitigate these impacts and all reasonable alternatives. Fairfield Farm, this case actually has a new development coming up. On May 5th, I will be arguing this case before the United States Court of Appeals for Circuit. This is the court that hears appeals from all federal trial courts in South Carolina, North Carolina, Virginia, Maryland, and West Virginia. This case involves the clearing, grading, and construction activities for a wedding venue in Pickens County, right along Highway 11. This is right next to the Jocassee Gorges area. And essentially what this company did was, this is a predominantly undeveloped portion. And you can see in this image in the bottom left corner, this is a primarily undeveloped area. And you can see the extent of the grading that they did on this property. The problem is when they did this grading, they disregarded the requirements of the Clean Water Act, and they failed to get a permit. They failed to install even the most minimal sediment control measures to ensure that sediment, sand, dirt from these activities would not transfer off-site, and importantly, not transfer into adjacent waterways. And so what happened here was we ultimately got involved and filed a lawsuit in federal court under the Clean Water Act, alleging that they failed to comply with the law. And our clients own property adjacent to this. They are the Natural Land Trust. They purchase properties to protect them for their ecological value. We also represent the South Carolina chapter of Trout Unlimited, a group of anglers who promote and protect cold water fisheries in South Carolina and nationally, the organization. These construction activities dumped literal tons of sediment off of this site into the unnamed tributary of the Eastatoe River. And the Eastatoe River is a popular trout fishing destination in Pickens County. And for anybody who does any trout fishing knows that you don't want your water to look like that. Cold water fisheries, trout fisheries require cold, clear, well-oxygenated water. And this sediment essentially devastated this stream, and this stream flows to the Eastatoe River. This is another photo on the left of, you can see the cloudiness of the water on the right. This is not the same spot, obviously, but you can get a sense of what the water should look like and see the comparison of what they did and what it should look like. This sediment devastated the river, killed fish, killed the microinvertebrates that they rely on, and affected our clients' property interests, and negatively affected Trout Unlimited's recreational opportunities.
I forget, what did Arabella, what are they wanting to do? What was that expansion that they were doing? What was it for?
In that top left corner, they were building an event venue. They hold weddings and things of that nature.
They
there.
don't have one there now?
I'm sorry?
They didn't have one originally?
No,
No, that was, okay.
the image on the bottom left was what the property used to look like. Before that, it was all forested essentially. Yes.
Who are you suing? The people who made a mess, or people who sort of been watching before the mess started?
Well, our suit is against the owners and operators of this event venue and this property, the ones who engaged in this construction activity. And essentially, our lawsuit seeks to hold them accountable for these violations. And the issue before the Fourth Circuit is, after we filed our lawsuit, the district court dismissed it, finding that a particular provision in the Clean Water Act precluded our suit because there had been some administrative enforcement undertaken. And what we're arguing in the Fourth Circuit is that whatever enforcement that they did, it was entirely private, and that fails to comply with the Clean Waters Act requirement for comparable public notice and participation opportunities in the decision-making process in administrative enforcement. Yes, ma'am.
Is Trout Unlimited currently involved in this action? Like, if they were to lend their support, would that help?
They remain a party.
They are a party.
The South Carolina chapters of Trout Unlimited remain a party, but the national organization is not a party. Yes, ma'am.
I don't understand how it got to this point. Where was the county oversight of the laws that watched the development of the clear the land, and was there no supervision? There are no county laws.
Essentially, the development.
Michael, could you repeat the question, because the people at home will not hear?
Sure. The question was essentially, why did this ever happen, and where was the oversight to prevent this from happening? And the challenge with environmental compliance, environmental protection, is it is often operated under a sort of layered oversight approach. The Clean Water Act is a federal statute, but the EPA delegates its permitting authority to the state, and then counties also have sort of on the ground immediate oversight over potential violations. And so the Pickens County did get involved. They issued stop work orders. DHEC ultimately got involved, but it was far too little and far too late. That type of grading does not just happen overnight, and that is a significant amount of work to be done that should have been addressed far before.
What's the status of the case now?
It is on appeal, and the Fourth Circuit will hear it on May 5th. For anyone who's interested, the court provides live audio feeds and audio recordings if you're not able to observe in real time. It will be, I I suspect our case will start around 9:30 or 10 on May 5th. And I can certainly share with Daniel, who can share with the rest of you the link to that recording.
I may have missed it, but is the work still ongoing or is it stopped?
To my knowledge, the event venue has been constructed. And so I don't believe there is any more ongoing work.
How long will it take for to recycle to where things will be? The damage done, how far will it?
It's our position that Fairfield Farm needs to excavate or remove the sediment that they put into this water. These I'll call the Article 3.1 cases. You may have seen a lot about this issue in the Greenville News and the Post Courier. Generally, these three cases involve proposed high-density subdivisions in basically the most rural parts of our county. And a particular land development regulation adopted by Greenville County sought to address this issue. And what it required was that before a subdivision could be approved, it had to, one of the criteria was that the project had to be compatible with the surrounding land use area, surrounding land use density. And the Planning Commission I'll first speak to Fuse Crossing and Oakdale. In each of those cases, the Planning Commission approved the developments and specifically and explicitly said that that provision doesn't apply because it was in an unzoned area. There's no legal basis in the regulations for that reading. And so we filed an appeal from those approvals. And last fall and winter, the circuit court agreed with us and remanded these subdivisions to have the law properly applied. It's my understanding that Oakdale, the landowner, ultimately sold to somebody else because the project was not being approved timely, and so I don't believe that Oakdale will be built at any point. As you can see, this is Ethan Richards' estate, but this area, Tigerville, the northern part of the county, is very similar to what you see here, very rural, very limited development. And so, each of those cases, we wanted to prevent these really high density subdivisions from going in without adequately considering the impact on the surrounding environment and the general character of the area. The top right corner, this is our comprehensive plans future land use map. And essentially it envisions that these rural areas will remain rural. And if development goes there, it should have a minimal impact on the character of the area. With Tigerville, this case was a little bit more complicated. The developer proposed the project. It was approved by the Planning Commission. And then after some complaints from constituents, a county council member moved for reconsideration of the development. So it went back to the Planning Commission. The developer wasn't adequately noticed of the hearing, and the Planning Commission reversed their prior approval and denied the approval. The developer appealed that denial, and we moved to intervene. We represented landowners who lived nearby, who would be negatively affected by this high density subdivision. Ultimately, the case ended up in a settlement. You probably read about it. The county had to pay the developer $100,000 and approve the development, essentially partly because of those issues with notice.
You saying it's approved?
Yes. as part of the settlement agreement.
Michael, how do you, these landowners that were adjacent to this property, how did they get in touch with you, your firm, and your organization to get representation from you?
So we have been, this was actually before before I came on when we initiated these cases, but we have a help request function on our website where people can reach out and inform us of issues. My predecessor, Michael Corley, had also been working on this and advocating for changes to our land use regulations to protect areas like this. And we have partnerships with organizations like Upstate Forever who are involved in this. And we collaborate on a lot of things. And so I'm not sure exactly how we got involved in these individual cases, but we were contacted at some point and retained to represent the various landowners in each of these cases. Pickens County landfill case. This is as maybe a theme you're recognizing. Another kind of complicated case. Back in 2007 or 8, Pickens County entered into an agreement with a landfill company to operate a Class 2 landfill in Pickens County. 7 or 8 years later, the landfill sought to obtain a modification of their permit from DHEC to install a liner in the yet unconstructed landfill. Fast forward a few months, Pickens County realizes that this is happening, that the permit modification has been approved. No, the public was not notified, Pickens County was not notified, and so they ultimately filed an action in the administrative law court to challenge the permit. And we got involved later at the appellate level when the administrative law court dismissed the action, claiming that it was not timely. And part of the issue on appeal was the determination by DHEC that this was a minor modification. And they can issue permit approvals for minor modifications without going through the public notice and participation process. Whereas a major modification, which we contended this was, would have to go through that process. And what happened was Pickens County became alarmed that what they wanted to do, what the landfill company wanted to do by installing this liner was be able to accept coal ash, which Pickens County certainly did not want and was not part of their original agreement. And so we ultimately won on appeal at the Court of Appeals and the South Carolina Supreme Court, where the court said that before the administrative law court can decide whether our challenge was timely, the court has to determine whether it was a minor or major modification. And so that issue remains pending at the administrative law court as of now. But part of this case, the importance of this case was ensuring that the public is adequately informed of these issues and these developments that are going to negatively impact their community. Lastly, Cook's Crossroads. This is one of our newer cases. This is a case that we filed in Dorchester County. We represent a nonprofit organization, Dorchester Trust Foundation. It is an organization that manages and operates a public park, Rose Rock Park. And this area is known as Cook's Crossroads. It is what the county itself has designated as the gateway to the Ashley River Historic District. And there is a major effort to turn this crossroads into this destination to provide this gateway to the Ashley River Historic District. And as you can see in the map, the Ashley River is located right there. And part of the goal of the county in adopting its comprehensive plan and adopting its zoning ordinance scheme and specialized design guidelines for this particular area is to protect and restore the Ashley River and the Ashley River floodplain, and to ensure that stormwater management, stormwater runoff is paramount importance and considered in development. And so initially, the county's ordinances specifically prohibited gas stations as a use within this area. Fast forward a year or so, and after a gas station company reached out and said, we want to put a gas station here, the county council decided to reverse its prior decision and adopt an ordinance that allows gas stations in this area. And so we followed suit on behalf of the landowner, Dorchester Trust Foundation, that operates this park and owns the land, to challenge this ordinance as being arbitrarily and capriciously adopted, which is the standard that we have to apply, given that it conflicts with state law requirements regarding zoning ordinance purposes, that it is not in accordance with the comprehensive plan that was adopted by Dorchester County, and generally violates laws surrounding the adoption of ordinances. This is like the Pickens County case, like the Tigerville Farm case. This is partly a good governance issue, and ensuring that when the government acts, that the public's interest is observed and followed, and the public's vision through the adoption of this comprehensive plan and these specialized design guidelines is implemented and not simply ignored for convenience sake. And so we filed a lawsuit against the county, against county council, seeking a declaratory judgment that this law is null and void, that it was arbitrarily adopted, and that the county cannot adopt any other similar statute or ordinance that would conflict with that state law, the comprehensive plan, and its overall zoning scheme. I just want to thank everyone for coming and listening to me today, talk about the work that we do. In case you're wondering how you might want to get involved, of course, we are a nonprofit, so any donations are always appreciated. But in any case, please follow us on social media, Facebook, Instagram, Twitter. We don't yet have a TikTok. You can also subscribe to our monthly e-blast at skelf.org/subscribe. I've also placed some sign-up sheets up here at the front that you can sign up with us at, and we can get you on that list. We also do a biannual published newsletter that we send out to anyone on our list, and so you can reach out to our office manager, Debbie@skelf.org, with your name and mailing address, and she will send them out to you and send them future ones out to you. Finally, like I said earlier to a question, the public is really a key component to our work and informing us about issues that they see happening in their community. Because we're a small team, we simply don't have the resources to know about everything all at once, and it is incredibly essential that the public can contact us and let us know, hey, I've got this problem, can you please help? And we may not always be able to provide actual legal services to you, but we will generally be able to provide advice on the situation, how you might be able to move forward with it, and ultimately, if it's something that we really believe can use legal intervention. We provide our services pro bono. We serve the public's interest, and we want to make sure that our laws are enforced, protecting our environment, and that they're executed in a way that protects the public's interest. So thank you all very much, and I'd be glad to answer any questions you might have.
Just for a few questions, there is a sign up sheet if you'd like to sign up and get the email blast. Michael said he's gonna send me an email and make sure it goes into the Ollie notes. Used to be what's good for General Motors is good for, the United States. Now we have to be sure it's not what's good for the developers necessarily good for the environment. So I'm glad we have people like this and organizations like this to protect us and make Greenville a special place that it is and keep it out there. So we've got time for a couple of questions. We've got one right here.
First, I'll say thank you for coming. There's a case going on right now, was half a mile from here called Blue Sled. Can you comment about it and tell us anything about the status?
I am somewhat familiar with that issue. My understanding is it will go before the planning commission in a week or so. We have elected not to get involved in that particular case, but I think the county needs to consider how this development would impact this lake that flows to the Reedy River. Should not be doing anything that further deteriorates the Reedy River. And for anyone who doesn't know about Bruce Lake, it's a proposed development of townhouses on this private lake, and they would use the lake as their stormwater detention pond. And there may be some particular issues involved there, but I think most importantly, the planning commission and the county needs to take into consideration the effect on water quality by this proposed development.
Thank you. Thank you.
Do you ever see zoning actually happening in Greenville County or South Carolina for that matter?
So one of the tricky things about the Article 3.1 cases and that particular issue, we spent a lot of time advocating for an improved replacement of that particular ordinance. We wanted to see regulations and zoning ordinances that really protect these areas. And we advocated for a version of what was ultimately adopted that incentivized and required conservation subdivisions, essentially, that would preserve a set amount of open space depending on the specific amount of residences that would be built for the density of development. Zoning, unfortunately, in this much of South Carolina is seen as a very negative thing. And what I frequently tell folks that reach out is there are few things in a society that can bind other people and not bind yourself. And so unfortunately, zoning will protect you, but will also restrict some of your usage. And so to obtain the protection, you've also got to accept the restrictions. And fortunately, the county has recently adopted an agricultural district that I think would benefit a lot of our rural areas to ensure that those areas remain rural and support profitable farming and rural uses. In terms of how to improve that process, county council needs to reconsider its decision to not streamline the initial zoning process. What is in effect now is really cumbersome and takes quite a long time and requires a lot of individual residents to get involved and to consent to it. And I think they need to streamline it so it's more like a rezoning process and not as cumbersome as it is.
One more question that we have. Last question.
What would it entail for Arabella Farms to clean up what they've done?
Could you repeat the question for us?
Essentially, what would it entail for Arabella Farm to clean up the river? You know, there's different proposals that I think we would need to consider. Obviously, one that is very labor intensive would be simply literally having a bucket brigade and just pulling sediment out of the river. You know, there's other proposals that would involve specialized equipment and machinery, but you know that presents its own issues about affecting the surrounding environment. So it's really difficult to say how exactly it would be done, but I think something needs to be done, and it really exemplifies the fact that we need to prevent stuff like that instead of having to clean it up.
Okay. Thank you all for coming. If you'd like to sign up for the get emails and these the different publications that they have, there's sample publications out here if you'd like to get them. And once again, thank you, Michael, for coming today.
You set up an office and easily click. How about Spartanburg?
Well, I'm actually covering the entire upstate, so please contact me if you have any issues.
My husband fishes. He's on this too. It's so large. So large. And the impact on yes, yes, yes. So I like all of that. Just
Yeah, and you know, approval of part of the issue that often arises.
We're not in church.
Planning commission. They're not really.
And the Rolling Green group joined us as well, so that was great.